اللي هم طبعا عندنا محكمة أعلى وعندنا محكمة عليا اللي هو السبريم كورت، اللي هم مولانا جيمي سلالة اللي هو الرئيس بتاع المحكمة، وعندنا ستيفن سايمون، وعندنا كمان مولانا ايزاك فور. هم الثلاثة دول هم اللي مسؤولين من المحكمة. لا سوبا. There's one thing I want to clarify to people. The difference between the special court and the normal court أو المحكمة العادل اللي نروح فوق اليوم ده. لو في قضية مثلا بتتكلم في normal court it may take from 2 to 3 years to 1 year. The special
لذلك أنا كم قريب السوبر من أسامي ناس القضاء اللي بيجي يشارك أو الإجراءات. كمان جانب بتاعه ستيفن سايمون والقاضي إسحاق فور. وبالتالي فريق النيابة العام من 13 مدعي عام من بينهم المستشارين العامين.
Yes, viewers of SSBC, thank you so much. You're still joining us live from Juba, both in our studios and also at Freedom Hall, where the court proceedings is taking place for suspects who are actually in connection with the Nasir incident. And of course, as the saying goes, that a suspect is innocent until is proven guilty by the court of law. And this is what is happening as you've been watching us live.
وتكون فريق الدفاع عن الدكتور رياض مشار المتهم الآخر من 6 محامين اللي هو بداية برأسه دكتور جيري ريموندو ومحامي كورلوان ومحامي أنيس تومبي والمحامي دينغ جون ومحامي وريانغ أكير ويانغ ومحامي ريجينا أكيرا ودين. وبتشمل القضية كمان محققين اللي بيدعموا الادعاء بما في ذلك بما في ذلك اللي هو بكون الكابتن القانوني من جهاز الأمن الداخلي كابتن ريتشارد كاتشي وهو المشتكي، والقاضي اللي بيترأس المحكمة الدكتور أكد إنه رياض مشار وغيره من الكبار أعضاء الجمهور لتحرير السودان IO إنه الإجراءات هي جلسة عامة وكمان الاستماع عام ممكن يسمح لوسائل الإعلام وكمان من الناس بالحضور. اللي هو بكده بنمشي طوالي بعد شوية محكمة حتمشي تبدا لانه مفترض كان يبدا الساعه 9 بالضبط، لكن هسه هنا في 14 دقيقه بعد الساعه 9 صباحا. انت لسه بتستمع لإذاعة اي راديو، ونحن بنقدر المسؤوليه ان بقدر كونكتكم لاجراءات القاضي يعمل نفسه حاليا في محكمه اللي هو في ده بكون في فريدوم هول في صباح بتاع يوم تاع الليله. The special court is set to resume proceeding this morning the trial of the suspended Vice President Dr. Riak and his co-accused following the 5-day adjournment. The presiding judge, James Alala, had ordered the break last Wednesday to give both parties significant time to prepare for their cases, allowing the court to review written submissions and reduce disruption to the public daily activities. The adjournment was welcomed by local observers who noted the positive impact on traffic and business near the court during the pause. Security remains tight around the court premises as the trial continues, with both sides expected to present additional agreement and respond in this high-profile court. And we do have some comments on Facebook, لكن للأسف إنه أن لسه ما عندنا صوت لأنه القاضي لسه ما وصل، لكن بقدر الإمكان هنا بنحاول بجد. كان محكمة ده بدأ ساوند بكون هناك اللي تكون في فيسبوك، لكن لحسي احنا لسه بنتواصل ونديكم كثير من الابديت. وفي صباحية يوم الليلة معنا مايكل وكمان اللصوبة.
طيب ديكو، خلينا برضو نقول حاجة إنه المحكمة بدأت قبل أسبوع اللي هو يوم الاثنين الفات، واستمرت جلستين. بعد كده القاضي جاء هو adjourned the session اللي هو ريزيوم الليلة احنا حضرنا جلسه يوم الاثنين ويوم الثلاثاء والاربعاء. then he adjourned the session على انه الليله يكون في ريسبون للكونسيرن اللي been raised by the two teams, the defense team وال prosecution team. زي ما كلنا عارفين انه المحكمه كانت قدمت almost عدد من المتهمين. النيابه قدمت عدد من المتهمين للمحاكمه، ومن ضمنهم يمكن هو السيد بودكان وزير البترول اللي هو المتهم الاول. بعد كده في باقي المتهمين برضه من ضمنهم الدكتور رياك مشار اللي هو النائب الاول للرئيس الموقوف. في عدد من التهم يمكن اللي هم قدمتهم المحكمه ضدهم في 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 القضيه دي. يمكن الليله القضيه مهمه جدا ومفصليه الجلسه بتاعت الليله، لانه القاضي will determine whether it will continue with the court session، لانه لو قدر يغني عن التيم بتاع الدفاع بانه الجوريدكشن بتاع المحكمه it's right then we will continue. بعد كده حنسمع المرافعه بتاعت الاتهام و the prosecution team will talk and giving the indictment speech هيتكلم فيها why ليه هم جابوا الناس دي في المحكمه. بعد كده ده لو الجزء الاول ما ده مربوط بالجزء الاول بتاع انه the judge now have to explain and convince the other team انه no المحكمة عندها jurisdiction, they have that right, they have that jurisdiction to trial react and the other and his co-associates. لو ما قدرت then المحكمة حتنتهي عليه هنا، لانه ده السؤال الجوهري اللي اثاره فريق بتاع الدفاع from the first session انه they were questioning jurisdiction of the court. هل هي عندها الصلاحية أو عندها السلطة to trial دكتور رياك and the others or not. أوكي؟ باقي الحاجات ديك سهلة، إنه المحامين ما جددوا، إنه المحامي بتاع المفروض محامي خاص يقعد مع فريق الاتهام. all those things are easiest. المعضلة الكبرى اللي هو لو عدينا من الجزئية دي طوالي حنخش في الاندايتمنت سبيتش اللي حيقدمها التيم بتاع البروسكيوشن، حيقدموا يوضحوا. بعد كده حنبدا اجراءات المحاكمه. ده كله حيتم 200 بعد ما القاضي يجي ويوضح، لانه البدا from the first day up to now it was just observation، لانه القاضي كان بيسال ال two teams عندكم any observation before we start the trial، فده كان كله عباره عن observation between the two teams لحد الان.
اوكي. في ناس بيسالوا عن مده بتاع المحكمه ده، لانه اوريدي 3 يوم في الاسبوع الفات عمل مشكله كبير خالص في مدينه جوبا. هل احنا ممكن نقدر انه مدى بتاع المحكمه حتكون اسبوع، حتكون شهر؟
اوكي، نرجع لحته ثانيه جزئيه قبل I start talking about it، اللي هو الموضوع بتاع الاستابليشمنت اوردر بتاع السبيشال كورت. السبيشال كورت ده من عندها فتره معينه، يعني القاضي وهو بيصدر التشيف جاستس when he was writing the establishment order he will determine البيريود بتاعت الكورت بتقول به for how long، يعني شهر ل4 شهور ل3 شهور. ما زي القضايا العاديه. القضايا العاديه انا ممكن استأنف واجرجر واخذ معك 3 4 5 years. هذه القضيه بتاعت المحاكم السبيشال كورت از كومبليتلي ديفرنت في الاستابليشمنت اوردر بتاعها، لانه بيكون واضح اي حاجه المفروض المحكمه بتاخذ فتره قدر شنو. فالمحكمه ما بتفوت من بين شهر ل4 شهور 5 شهور دائما. this is الليميت بتاع السبيشال كورت.
برضو في السيشن لايك it's a proceeding as a correction. الأسبوع الفات برضو تذكرت على أساس is not the proceeding of court proceedings of Dr. Riak, is a proceeding of Podkang and the others. Why there's this؟
لأنه هو is the prime suspect according to الخطاب اللي قروه من أول يوم. دايما بيقولوا إنه Podkang is هو المتهم الأول في القضية. فالموضوع ما عنده علاقة. نحن ممكن نتكلم بالرياك لأنه رياك as a position هو كنائب أول. لكن المتهم الأول البرايم سسبكت في القضية حسب الورقة الموجود هو بودكانغ. فبعد كده انت لو بتقرأ بعدين هتلقى أول ما الخطاب بتاع الاندايتمنت يبدأ القاضي وكيل النيابة هيبدأ ولا start reading the names، هتشوف انه في منه who is the first, who is the second, who is the third لحد. وبرضه ما تنسى انه في some accused are in at large. وفي ناس some were released also. في كان بعض المجموعة they were released. ما لقوا due to insufficient evidence against them، يعني ما كان في أدلة كافية بدينهم so they were released.
I think Lesuba you can add something. Because some people are saying we are now directing ourselves to too much Arabic. Okay.
Yeah, I think Michael has rightly explained the nature of the court proceeding.
Yes.
And what we know is that it's not yet, I mean, the accused are not being tried yet, because when the session is started on Monday last week, yes, the judge, gave the platform to the prosecution and defense team to make the observation. And Michael rightly said the defense team raised a concern over the jurisdiction and competence of the court. They presented the argument, and there was a response from the prosecution to that. And both teams have made written submissions, and these submissions were actually delivered to the special court. And it is then that the special court on Wednesday last week adjourned the session to today, yes, in order to have, he explained that to give ample time to the special court to make a decision. Yes. And so the decision, as Michael said, will determine whether the trial will proceed or not. If the judge says that it has the jurisdiction and justifies that, then it will definitely proceed with the trial. If not, it has to take another step. I don't know what it will do, but other experts were saying that he can decide to refer the matter to the Ministry of Justice or something like that, maybe for the case to be reviewed, yes, or the proceeding to be reviewed, and it might actually call for further discussions or deliberations on the way forward. So there are many options that the judge can rely on, but we cannot predict what it is now, because now the session is due to begin. So this is exactly how it is. The matter has been handled so far, and we are keeping our fingers crossed to see what would be the end results today. So we already know that Michael has explained that there is normally the order from my observation and previous stories that we wrote of suspects who were tried in court, especially a case involving many suspects. And there is an order, what we call first accused, second accused, depending on how many suspects are there, and actually the nature of the case itself, and their involvement in that particular crime. So this is how it is. So given the fact that Port Kang is read as 1, and Machar 5, and the rest in the middle, and the others in the end. So it probably explains the nature of the alleged crimes that each of them participated in, if allegedly participated in, so we can't. But that is the nature of a court. You have now the the defense team to counter that, if only the special court is to proceed with the trial after it decides today. Yeah, so that's it. And yes, we will see what happens. And of course, we expect that if any decision by the special court will stir the minds of South Sudanese experts, people will begin to react, certainly, to how or to the decision that the special court will make. In the meantime, we cannot discuss them because it would be we cannot discuss the arguments of the prosecution and defense team over the jurisdiction and competence of the special court, because it would be like actually a contempt of a court. And so we will just will wait for what decision will be made, and people will have insights into how the process was done itself and the arguments that were presented. And this is how it is.
Yeah, what I can say, what is being seen today, obviously, is the the attendance. I think this is one of those things that show how the security organs that respect the court order. And let me say one thing, that the courtroom,
Yes.
the responsibility of the judge is nobody else. He is the one in charge of the courtroom. That if you do remember from the first day, he put some ground rules.
Yes.
He is the one who has that right. So if you violate those rules, he has a right to put you in jail for 24 hours.
Okay.
So that's why whenever you go to courtroom, the first things you have to know that if you, it is not your defense lawyer, it is not the prosecutor, it's not the police there, it is the judge himself. He's the one in charge in the whole room. He can say who can sit in, who can go out, who can do what. So the court have to be respected.
Okay.
Yeah, especially the court order have to be respected.
Okay.
So that's why we see today a lot of people were inside there, and I know this
Even
is
the media, we saw the
So,
team
so
outside
ground.
there.
So
Yes.
those are ground rules.
There's a question I would love to for you both to highlight. Like, can you explain the role of the 2018 revitalized peace agreement in the case? Because how does it define which court should try serious offense and who gets immunity?
As I said earlier, the matter is being argued by the prosecution team.
Yes.
And
this part.
and a defense lawyer.
Yes.
So we do not have the right now to discuss it, and this will be determined, as I said earlier, by the decision of the court, and what argument or justification it would give to convince its decision that it has arrived at, or how it has arrived at. So we'll have to leave it there.
يس أصل سوبا سيت الموضوع مرتبط بأنه ما موضوع منو صح ومنو غلط لأنه المحامين بتاع الدفاع بيقولوا إنه ده مذكور في الاتفاقية والاتجاه الثاني بيقول لا. فالخلاف ده كله هو السبب بتاع الجلسة حقت الليلة. فنحن هننتظر القرار اللي بيصدر من القاضي، فعلى ضوءه حيكون حل الخلاف الحاصل ده، لأنه الموضوع بيرتبط في النهاية وفي الأول بموضوع بتاع jurisdiction. فjurisdiction ده بيحددوا منه القرار اللي بيطلع من القاضي بعد شوية. We are all waiting for his result to come out, and then according to that, as I said before, هل احنا هنكمل we'll continue في process بتاع ال court session ولا will end ولا what will happen. This is the الكلام ده كله بيجي 200 بعد القرار اللي بيجي يصدر من المحكمة، لأنه this is the main reason القاضي أجل adjourn the case from Wednesday to today to respond to this one.
All
Right.
right. And I think in a few seconds we are going to be connecting you to the court. Already the judges are already coming in. So ladies and gentlemen, we're leaving you here, and later we'll be back to connect you with us.
Yes, viewers of SSBC, thank you so much for joining us. You're still watching live coverage on the court proceeding for Potkang and other accused. Live from Freedom Hall, you've just watched the panel of presiding over judges have arrived at the courtroom. And from here, viewers will be handing over the microphone to the presiding over judge, Dr. Justice James Alala Deng, who is actually supported by 2 other justices, including Justice Isaac Pur Majak and Justice Stephen Simon. Let's hear the final verdict as they preside or they take center stage of this case at hand. Back to Freedom Hall, where we hear from the presiding over judge as they have arrived. Stay tuned.
Morning to you. Let us start our session by giving the attendance to the court.
Honorable Court, my Lord, Denga Shula Liya, Procedural, Minister of Justice, the President of the investigator, the complainant, and the prosecution team in present. Thank you.
Good morning, Your Lordship.
Just wait. Yes.
Good morning, Your Lordship. Of Advocate Gary Raimondo Lege Lobate, the lead defense team, in the presence of my learned colleagues, Advocate Kurulwal Kur,
Present.
in the presence of Advocate Kurulwal Kur, Advocate Anis Tombe, Advocate Deng John Deng, Advocate Ornyang Kir Ornyang, representing women in our side,
Thank you.
in the presence of the 8 accused person, 7, 8. Thank you.
Thank you. Session is for. I think the session is today is the decision on the 2 objections, the one of the defense and that of prosecution. Thank you.
Okay, good morning. Let's go direct to the decisions, and I'm going to read it out. On the 1st of September 2025, the President of the Supreme Court and the Chief Justice of the Judiciary of South Sudan constituted this special court to try criminal case number 1533, 2025 for Nasser incident, March 2025, against accused person under sections 48, 50, 52, 61, 62, 65, 64, 65, 66, 67, 70, 71, 72, 75, 76, 206A and B, and 239 of the Penal Code Act 2008, and also sections 15A, B, and 16 of anti-money laundering and Terrorism Act 2012, amended. On 22nd September 2025, the defense presented to the court an objection called preliminary objection. The title, Objections on Lack of Jurisdiction of the Special Court to try the first Vice President and the 7 others accused persons. That may be summarized as follows. Number 1, supremacy of revitalized agreement. And number 2, jurisdictional and procedural objection. Number 3, counter objection on the appearance of private advocates as part of the public prosecution attorney's team. As for the supremacy of the RI revitalized agreement, the defense cited Article 8.3 that says this revitalized agreement shall take precedence over national legislations and existing agreement to the contrary, and in the event that the provisions of national legislations or of previous agreement conflicts with the terms of the agreement, the provisions of this agreement shall prevail. And that the revitalized agreement 2018 provides under 5.3.1.1 for the establishment of hybrid court for South Sudan. This court is independent and established by African Union Commission to investigate and prosecute individuals bearing responsibility for violation of international law and applicable South Sudan laws. Committed from 15 December 2013 through the end of the transitional period. Nasser incident is a ceasefire violation, and therefore it falls within the jurisdiction of the hybrid court. Article 17 of the revitalized agreement 2018 that should be adhered to. Read together with Article 5.3.1.2 and 5.3.2.2. In addition to Article 201A, 7A, B, and D of the Transitional Constitution 2011 as amended. Furthermore, the defense mentioned that Article 9(3) of the Transitional Constitution of the Republic of South Sudan 2021 as amended provides that all rights and freedoms enshrined in international human rights, treaties, conventions, and instruments ratified by or acceded to by the Republic of South Sudan shall be an integral part of this bill. So, trial of the accused persons disregard and alter-verse and unconstitutional. The defense also raised an issue of jurisdictional and procedural objection on the constitutional immunity of the first vice president, citing Article 103, 104, 2 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended, read together with Rules 62 and 63 of the Transitional National Legislative Conduct of Business, 2013, as amended, 2021, that provides that the first vice president shall not be subjected to criminal proceedings while in office, except upon removal of immunity by 2/3 majority of all members of the National Legislative Assembly, and in accordance with the Rule 62 and 63, that provides that the provision of 62 shall, with the necessary modification, apply in respect of the first vice president and vice presidents. This raises questions as to when does court become competent. It is when it is properly constituted as regards yes, it is properly constituted. The subject matter is within the jurisdiction of the court, and case is put before the court based on due processes of law. This court is defect in its competency, since the President of the Supreme Court has no power to establish it before to establish it has no power to establish it before provisions of the Transitional Constitution 2011 as amended, Article 103, 104, 2, and provisions of the Transitional Legislative Assembly 2013 as amended, 2021, Rule 62, 63 are adhered to, and also lack of resolutions that shall have been passed by the 2/3 majority of members of Transitional National Legislative Assembly as amended. The arrest and detention of the accused were carried out without due process of especially lifting of the immunity of the first vice presidents, first vice president. And therefore, the proceedings are unconstitutional, unlawful, and void. The accused person shall be immediately released, plus any other reliefs deemed fit by the court. The response of the prosecutions may be also summarized as follows. Number one, that provision of revitalized agreement 2018 and transitional constitution 2011 amendment number 6 2020 limits jurisdiction of hybrid court to international law crimes and crimes under relevant South Sudan laws, including gender-based crimes and sexual violations, when and if established. There is no conflict between the revitalized agreement and national law in this case. The two are distinct. Number two, that it is only the president who is immune during his or her tenure of office, according to Article 103(1) of the Transitional Constitution 2011 Amendment number 6, 2020, and Rules 62 and 63 of the Transitional Legislation Conduct of Business Regulations 2013 Amendment 2021. They deal with the removal if the vice president and not trial, dealing with the removal of the vice president and not trial of the same, since that does not override provision of the Constitution. Number three, that according to Article 123(e) of the Transitional Constitution 2011 as amended, the Judiciary Act 2008, Section 7F, and the Code of Criminal Procedure Act 2008, Section 16(4), give the President of the Supreme Court powers to constitute a special court to try any person accused under Chapter 5 and 6, inclusively, of the Penal Code Act 2008, and a written order for establishment of special court as required under Section 44 of the Code of Criminal Procedures Act 2008. Therefore, the special court has been duly constituted in accordance with the law, and it follows that the court is legitimate. Number four, that the Minister of Justice has power under Section 45 of the Ministry of Legal Affairs and Constitutional Development Organization Act 2008 to engage any advocate outside the ministry whenever necessary. Each party stood its position in its response and comment to pleading of another. And according to that point for discussion and determination may be summarized as follows. Number one, supremacy of the revitalized agreement 2018 as embodied into the Transitional Constitution 2011, Amendment number 6, 2020. Number two, President of the Supreme Court has no power to constitute a special court to try national incidents crimes. Number three, immunity concerning the first Vice President who was not lifted when he was arrested. Number four, a special court established by the President of the Supreme Court is unconstitutional. Number five, that private advocates who are on the side of or within the public prosecution have no legitimacy and should be sent away. And the two advocates within the defense teams lack or have no license and should be told to go outside the court or sit with the audience over there. Now, it is evident from the submissions that main points for the determinations are to be discussed as follows. Number one, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court for its twice offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011, Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of the Republic of South Sudan, of course, when a conflict of law arises. So, the hybrid court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 3.214 of the revitalized agreement of 2018. It is obvious Now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the revitalized agreement on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the revitalized agreement itself to specify, those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid court are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018. The special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try national incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as is stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 124, 122.4, 126.2, G3, and 127.1b of the Constitution 2011, in addition to the provisions of Section 16.4 and Section 44 of the Code of Criminal Procedure Act 2008 and Section 11.3.7f of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 18 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that's from 15th December through the end of the transitional period is not meant to help or to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and the powers to prosecute offenses in the territory of the Republic of South Sudan. Therefore, it is the evidence that is the sticky yard to prove whether the subject matter of the trial belong to the hybrid court or national court. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 102 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Legislative Assembly Conduct of Business Regulations 20 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Legislative Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 104, 103, and 102, the Transitional Constitution 2011 has amended, and provisions of 62, 63 of the National Assembly Code of Business, Article 103.1 confers constitutional immunity upon the President of the Republic of South Sudan only. And Article 104.2 of the Constitution is dealing with appointment and removal of the first vice president Provision did not expressly or directly mention immunity of the first vice president and other 4 vice presidents. As for the provisions of rules 62, 63 of conduct of business stated above, deals with impeachment of the President of the Republic, and Rule 63 of the same deals with the removal of the first Vice President and the 4 Vice Presidents. The 2 rules cited by the defense do not talk about constitutional immunity of the first Vice President, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy, according to provisions of Article 3(1) of the Transitional Constitution 2011 as amended, which reads, this Constitution derives its authority from the will of the people and shall be the supreme law of the land. It shall have a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs the conduct of business of the Assembly, which is subordinate to the Constitution 2011 as amended, and therefore it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first Vice President does not have constitutional immunity. According to the provisions of the Transitional Constitution. Therefore, the objection is rejected. Number 4, whether the special court established to try Nasser incidents is unconstitutional or constitutional. The Transitional Constitution 2011 Amendment number 6, 2020 says Judicial Services Commission shall undertake appropriate judicial reforms and restructuring of the judiciary during the transitional period. But the structure of the judiciary remains as it is under Article 123 of the Constitution above. Other courts and tribunals are part of the structure of the judiciary as provided for in Article A of the stated Constitution. Section 16 of the Code of Criminal Procedure Act 2008 provides for special courts, and it's specifically subsection 2 of the above provides that the President of the Supreme Court may convene a special court to be presided over by a High Court judge or any other senior judge, to be assisted by 2 assessories for the trial of tribal or sectional conflict dispute involving capital offenses. Reading those provisions with the Judiciary Act 2008, we can say this is special court for Nasser incidents is constitutional and therefore has the competency to try the case as stated previously. Number 5, advocates here and there. Both parties to the case objected to certain advocates found within this or that team. Prosecution and defense. Prosecution's objection is that Advocate Deng, John Deng, and Warnyang shall not be allowed to be within the defense team because they did not renew their license according to the law. Advocate Act 2013. Failure to renew the license at the end of January every year, the license shall be deemed to have been suspended. The defense is not denying that, but saying they were deliberately denied to do so by the Bar Association. Since advocates are tasked to defend legal and interests of their clients, to prevent injustice as guaranteed in the national and international instrument, the defense prays the court to reject prosecution objection, considering the period from January, from the end January up to now. It is a long time. The advocates in question would have tried possible means to renew their license, including going to the court to settle the matter. Appearing before courts without valid license violates Section 26 of the Advocate Act 2013. It follows that joining defense team without informing or even taking permission from the court may not be upheld, since it is a constitutional requirement under Section 136(2) of the Transitional Constitution 2011 as amended, among others. The advocates shall observe professional ethics. The only way now for them to rejoin the team is to remedy their position by using Section 102 of the Code of the Criminal Procedure 2008 and seek out sanction of the President of the Supreme Court to appear before this court. As for the private advocates with the prosecution team, defense objection has no merit, simply because it is obvious from Section 45 of the Ministry of Legal Affairs and Constitutional Development organization that the minister may engage, advocate, or make use of legal expertise from outside the ministry whenever necessary. This is his or her discretion powers. Therefore, the objection is refused, and the decisions or the orders of the court are as follows. Number one, objections of defense teams are overruled. Advocates Deng John and Warnyang, Kir Warnyang, are ordered to leave defense team and seek sanction of the President of the Supreme Court to return back. Private advocates within the prosecution team are allowed to continue. Thank you. Sit down, finish. And after this, the disposal of these two objections, now we proceed to listen to the prosecution's number one witness, who is the investigator.
May it please this court, I would raise a procedural issue under section 224 of the Code of Criminal Procedure. And the procedural issue is that we are, as a prosecution, supposed to provide before this court our prosecution opening speech.
You are correct. Please proceed.
Thank you, my lord. Honorable court.
We are still the advocates who have been sent to go. Please let them go. And you are advised that you go to the Chief Justice and get his sanction and come back. We are very clear. All right. Please go. Continue.
Thank you, my lord. Honorable court, this is the prosecution opening statement or speech. In this case of Republic of South Sudan versus Port Kang Chol and others, criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench.
Don't be running. Just give us a chance to write. Yes. Opening speech.
This is a prosecution opening speech. We are going to give you copies of the same, and I will try to be as slow as possible as well, my lords. So this is an opening speech. Republic of South Sudan versus Port Kang and others. Criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench, with due respect and on behalf of the Republic of South Sudan, allow us to present this prosecution opening speech. On the 3rd through the 7th of March 2025, in Nasir County, Upper Nile State, the people of South Sudan and the world witness the gravest crimes that strike at the very heart of our constitutional order, endangered our national security, and traumatized and inflicted immeasurable suffering on the people of South Sudan. The government military garrison in which Yardiu, Nasir was attacked and overrun by the White Army militia. The government forces that surrendered on their own and those that surrendered on the persuasion of the fifth accused person, Dr. Riek Machar, including the late David Majur, who was to be evacuated by a UN helicopter. Those injured and those captured alive were rounded up and executed at point blank. The dead were dragged around and others dumped into the river and others left to rot where they were executed. My Lord Justices, on April 20th, the South Sudan People's Defense Forces, SSPDF, regained the control of Nasir Town and Wich Yardiu military garrison. At Wich Yardiu garrison, they were welcomed by the dry bones of their slain comrades. An apocalyptic scene comparable to the biblical phrase of Valley of Bones. But here, my lords, it was a barbed wire garrison, a plain land of bones overlooking the silent and grieving river. The prosecution stands before you today on behalf of the people of the Republic of South Sudan to seek justice for these heinous crimes committed by the accused persons. My lords, justices, this case is about individual criminal acts or omissions or responsibilities of the accused persons. I emphasize individual criminal acts or responsibility of the accused persons. The accused persons are namely Port Kangchol, Lieutenant General Gabriel Droblam, Mampal Duor, Garawich Lampoch, Dr. Riek Machar Ten, Brigadier General Camilo Gadmichael, First Lieutenant Mading Riek Yak, and Lance Corporal Dominic Gadgok Riek, who are present before you here, and others who are at large, namely Lieutenant General Peter Tokchuo Luak, Major General Dilin Care Cholkuj, Major General Peter Ruach, WBM, Lieutenant General Ye Dak, Will, Major General William Dengbom, Kang Makana, Major General Kong Miang, Kwang Terjes, Garawich Liam, Biel Will, James Galwak Liu, Brigadier General Hokdor Chuol, and Pal Mai Deng. My Lord Justices, investigations were conducted of over 100 people, and the rest were released. And only these were the ones the prosecution has presented before this court to have been found culpable in the criminal acts that they are being charged with. In due course, Mr. Presiding Justice and distinguished members of the bench, the prosecution shall seek the indulgence of this honorable court to permit the prosecution of those absent and at large in absentia. The Honorable Presiding Justice and distinguished members of the bench, the incident in Nasir in March 2025, characterized by brutal mass murder in cold blood, inhumane treatment, and total disrespect of the dead, and total disregard of the laws of South Sudan remains unforgettable and regrettable stain in the conscience of this republic. My Lord Justices, the prosecution will demonstrate that these were not spontaneous attacks, but actions of well-organized, well-financed, brutal criminal scheme. A criminal scheme carried out by the accused persons as they incited, organized, abated, financed, and weaponized a militant group, the so-called White Army, to target SSPD personnel, civilians, and undermine the government. My Lord Justices, the prosecution will avail evidence that the White Army did not act independently. They were under the direct command of the fourth accused person, General Gabriel Doplam, Major General Dealing Care, who is at large, and the fifth accused person, Dr. Riek Machar, and financed by the first accused person, Mr. Port Kangchol, and Mampal Duor, the third accused person. The attacks by the White Army were planned, funded, coordinated, and commanded by some of the commanders of SPLA-IO. We emphasize some of the commanders of SPLA-IO. The commanders in Juba coordinating the assault were Lieutenant General Gabriel Doplam and Major General Dealing Care. And on the ground in Nasir, the SPLA-IO officers commanding the White Army were namely the late Torgel, Thon, Kang Makana, who is at large, Lieutenant General Peter Thokchuol, Brigadier General Manpinj Pal, Brigadier General Peter Palmut Yaj, Bol Doyak, and Major General Kong Moyang. This means the attacks were executed under the direct orders of the fifth accused person, who is the commander-in-chief of the SPLA forces. The evidence the prosecution will present will establish this clear and undeniable claim and the chain of command. It will demonstrate that the militant White Army operated under the direct command and influence and the strategic direction of the accused persons before you and those at large. My Lord Justices, there is a false narrative that this trial is a political witch hunt against the fifth accused person, Dr. Riek Machar, and the other accused persons. Contrary to this claim, my lords, this trial is about the rule of law. It is about giving justice to the victims. It is about having a closer to the victims, fighting impunity, and setting a new departure that crimes must be punished, that there must be a new chapter of accountability for all, regardless of status. Albeit this, it is inversely an opportunity for the accused persons as well to clear their names. In this commitment to the rule of law, my lords, the accused persons before you are presumed innocent as per our Constitution until found guilty by this competent court. It is to this commitment that this trial is open to the public. Further, my lords, it is to this commitment that the accused is duly represented by a competent defense team. And the Republic of South Sudan is willing and in position, given the nature of the offenses herein, to assign lawyers in addition, if need be, to defend the accused persons. The Honorable Justice and the distinguished members of the bench, the accused persons, Port Kang and others, stand charged with treason, concealing treason, subverting the Constitution, insurgency, banditry, terrorism, terrorist financing, mass murder, destruction of protected property, treasury, attacks on United Nations personnel, unlawful seizure of a military garrison, and participation in an organized criminal act. These charges, my lords, are brought under the Penal Code Act 2008, the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended 2024, the National Security Service Act 2014 as amended in 2024, the SPLA Act 2009 as amended in 2020, and the Geneva Convention Act 2012. The prosecution will provide evidence proving beyond reasonable doubt that the accused persons committed the said crimes, and that the crimes are: 1, a crime of treason. Instead of paying allegiance to the Republic of South Sudan, the accused persons waged war against the state with intention to overthrow the constitutional government contrary to sections 64, 65, and 66 of the Penal Code Act. That the accused persons engaged in terrorist acts. The accused persons committed violence with the intention of causing forcible resistance to the government and to the defense forces and any lawful agencies, as well as possession and using dangerous weapons, contrary to sections 67, 70, 71 of the Penal Code Act. That the accused persons engaged in terrorist financing, the accused persons collected and provided funds with the knowledge that they would be used for terrorist purposes, contrary to section 14, 15, and 16 of the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024. That they committed mass murder. The accused persons abated the brutal and inhuman killings of armed SSPDF and wounded personnel, including the late Major General David Major Dak, the commander of SSPDF in Nasir, a UN personnel member, and 257 SSPDF personnel in Nasir, in violation of the Geneva Convention and the Penal Code Act, sections 10 and 206, respectively. That they committed as well destruction of protected property by damaging UN-marked helicopters, destruction of military equipment and civilian assets, contrary to section 67 of the Penal Code Act and the United Nations Convention on the Safety of United Nations and Associated Personnel, 1994. And that they committed treachery by consciously giving confidential information to the SPLA-IO commanders on the ground and in Juba, and withholding vital information from the SSPDF command, contrary to sections 64, 1, F, and G of the SPLA Act 2009 as amended in 2022. My lords, in terms of evidence, the evidence will point a picture of calculated violence that extended beyond military targets. It will detail gross violations of the Geneva Convention, including desecration of the dead and persecution of innocent civilians and UN workers. The prosecution will present a layered evidence strategy, beginning with testimonial evidence that will come from survivors, eyewitnesses, and protected witnesses who will recount the attacks, the planning meetings, and the consequences they endured. The prosecution will provide documentary and physical evidence like signed operational orders and autopsy reports. The prosecution, my lord, will provide digital forensic evidence like call records, WhatsApp communications, preserved and authenticated in compliance with international standards and international evidentiary standards. The prosecution as well will present expert testimonies from forensic pathologists, from digital forensic specialists, from military experts that will assist this honorable court in understanding the technical aspects of these crimes. This evidence will be presented chronologically, from the planning to the funding to execution to the aftermath, ensuring that each strand corroborates the other and eliminates reasonable doubt. My lords, the prosecution will meet this with the independent corroboration of witness statements, forensic and biometric evidence, authenticated through metadata, hash measures, hash values, and expert verification. In terms of procedural standards, my lords, the prosecution will assure the court that every exhibit is supported by an unbroken chain of custody. Vulnerable witnesses will be protected, including through in-camera testimony when necessary. In conclusion, my lords, this trial is a testament to our nation's unwavering commitment to the rule of law and to breaking this cycle of violence and impunity. The accused persons have been informed of their rights and their right to fair trial. We operate in a strict adherence to our constitutional standards and our obligations under international law. This trial, my lords, is about accountability, justice, and the rule of law. The evidence will prove that accused persons deliberately conspired to wage war against the state, terrorize civilians, and undermine the peace and security of South Sudan. At the conclusion of this case, my lords, notwithstanding the presumption of innocence of the accused persons before this honorable court, the prosecution shall respectively request conviction on all principal charges and the imposition of sentences proportionate to the gravity of these crimes, consistent with South Sudan laws and international standards. Allow me, my lords, to return the mic to you, if any, for the defense team to exercise their right of reply to our statement, and thereafter to the investigator who shall journey us through the process of demonstrating the evidence that shall be demonstrated before this honorable court to prove the charges against the accused persons. With this, my lords, justices, the prosecution remains appreciative of your patience. I end. Thank you.
Okay. Then the next step is that we go to hear the first witness.
Do they have the defense?
No, they don't have. The law is clear.
I think, Mala, you make announcement
Thank you, my lord.
Excuse. You know, it's very, very good. You know, while we're going to start, please, if there are witnesses of both parties within the audience in the court, are ordered to go out. If there are witnesses here in the court, let them go out. This is very important because if we discover that there was a witness inside the court listening to all these pleadings, we may not allow him to provide his statement. And also, let me take this opportunity to remind the media, those who are reporting, please stick to the rules of reporting, journalistic reporting. You should not go and start trying to pass your opinions or trying to analyze the facts that are given in the court. Please adhere to the law, to the provision of the law, domestically and internationally. So,
Let me repeat something.
all right.
أنا داير نقول شنو؟ أي زول بيعتبر نفسه شاهد للدفاع أو للاتهام من فضلك قادر هذا المكان. نحن ما دايرين شهود في هذا الوقت. أي زول شاهد يطلع. شكرا.
Now, let us begin with the first witness of the prosecution. There is no reply, according to the law, that the defense, no excuse, please sit down. Let's start. With
My Lord,
excuse. Sit down until I give you.
My Lord, as you pass decision on the objections which were noticed by the two parties, we in the prosecution team in the position to request your honor that this session to be adjourned for tomorrow for verifications, all the exhibits and evidence which in our side to be presented by the investigator. Thank you.
Yes, the defense, what is your reply? Do you have any objection?
thank you, my Lord. First and foremost, before I engage to respond to our colleagues in the prosecution, I'm praying from Honorable Court to avail us with a copy of the decision read to us for some minutes. We need a copy.
The opening speech is not given to you?
The ruling of this Honorable Special Court for our objection on point of law. We need a copy.
It's okay. You may be allowed to be given copy. Whatever you want. But what is your response to the request for the adjournment for tomorrow?
Before I respond to the prayer of our colleague in the prosecution to adjourn this session, we are governed by Act Section 224 of the Code of Criminal Procedure Act, specifically 224 subsection 2, which allow us as defense of the opening speech. We are given also the legal right hearing the defense, evidence of defense to respond to what the prosecution have stated. We are ready. My Lord, Your Lordship, subject defense respond to the public prosecution opening speech. We act for and on behalf of the accused, His Excellency Victoria Masharten, the first Vice President of the Republic of South Sudan, Put Kang Chol, Lieutenant General Gabriel Dub, Mampal Dor, Gadwish Lampoch, Brigadier General Camilo Gadmal Kel, Madingrial Yak, and Dominic Gadrog, respectively. We submit this response to the opening speech delivered by our colleague, the public prosecution, as follows. I want to bring the attention of our colleagues that in their opening speech, they just gave us a conclusion without giving us the facts. They have used command, influence, who command who, and who influence who.
Objection, my lord.
Yes.
My lords, based on the section cited, section 222, subsection 2B, that deals with the prosecution opening speech, there is nothing as a right of reply. If he's referencing subsection C, it talks of reply of the accused to the prosecution. That is a state that we have not reached to, because we are supposed to get into the statement of the inquirer, who is the complainant, and the statement of the complainant, if any, and the discussion of the same. What I was expecting is, my lord, based on our procedure, this is a special court. When the investigations were completed, the investigator and the public prosecution took the evidence to the court. But given the sensitivity of the matter, the court then, before the establishment of this court, the Office of the Chief Justice advised that given the sensitivity of these evidences, it should be kept by the prosecution and only be availed before this honorable court on the start of the prosecution case. So what we are expecting, or what we are praying for this honorable court, is we sought an adjournment to allow the prosecution and the investigator to submit to this honorable court the evidence that is available, because we cannot give it to the court since the Chief Justice had advised that the special court had not been established, and therefore we must come and submit it to the special court. And we request for this, my lords, in the interest of justice and following our rules of procedure. Thank you.
Yes.
Your Lordship, it seems that the prosecution have forgotten about natural justice. And natural justice, the element of natural justice are two. One, odi altrum patrum, which means do not condemn somebody unheard. Second, nemo judice impropera posa, which means a monkey should not determine the affairs of the forest, which means rule against bias, which is part of Article 19 of our Constitution. The right to be heard is enshrined in the Universal Declaration of Human Rights, 1948. It's also enshrined in the International Covenant for Civil and Political Rights of 1966, read together, International Covenant for Social, Cultural.
Objection, Your Honor.
Please, let him continue.
Are you forgetting our rights?
Please, continue.
We have spoken, and this is my time to talk.
It's okay. Please shut on your wrist.
Thank you, my Lord.
Yes.
My colleagues, Your Lordship, the prosecution alleges that our clients and 8 accused are guilty of serious offenses under Chapter 4 and 5, Section 206, 239 of the Penal Code, read together with Section 15A, B, and Section 16 of the Money Laundering and Counter-Terrorism Act 2012, as amended, read together with all the sections mentioned in the charges. To succeed, the prosecution must prove beyond reasonable doubt that the accused person committed each and every element of the alleged offenses unless and until the prosecution discharge that burden. The burden of proof lies on them to certification of this special. The presumption of innocence must prevail. First and foremost, Your Lordship, and before we indulge into the fact and the law applicable, we would like to emphasize on the role of a prosecution attorney, because criminal law or penal court involve a contest between the state and accused person. It is imperative that both sides are represented by competent and ethical advocates or attorneys. The primary duty of lawyers for state prosecution and the accused or defense is to assist the court and the process, and not to their respective clients as such. Thus, both sides have essentially similar obligations, although they come to their task from different perspectives. Your Lordship, a prosecution represents the state, not the victim. His or her duty is not to secure conviction at all costs, but to ensure that all the evidence fairly and accurately adduced before the court of law. Your Lordship, a prosecutor is the Minister of Justice who represents the government in the public prosecution according to provision of Article 135, Clause 3 of the Transitional Constitution of the Republic of Pakistan, 2011, as amended. The prosecutor principal's role is to assist the court to arrive at the truth and to do justice between a community and the accused person according to law and the dictates of her. A prosecutor is not entitled to act as if representing private interest in litigation. A prosecution or a prosecutor represents a community of South Sudan, and not any individual and sexual entity. A prosecutor acts independent, yet in general public interest. The prosecutor interest is to be understood in that context as in historical continuum, acknowledging debts to previous generation and obligation to future generation. Your Lordship, in carrying out that function, it behoved him neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, which credible evidence means believable evidence, reliable evidence, trustworthy evidence, evidence acquired according to law, not unconstitutional evidence or illegal obtained evidence, which will submit to this honorable court in due course. Let me repeat again. In carrying out that function, it behoved him, the prosecution, neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, nor to do even a little wrong for sake of expediency, or to pick any person or please any power, not to be either illiberal or suspicious, intolerant or overplanned, as we have realized from our colleagues there. In the firm and abiding mind to do right to all manner of people, to seek justice with care, understanding, and good confidence. They should not be biased to the government. They should be biased to the people of South Sudan. Restore justice in this nation, this beautiful nation of ours. Your Lordship, it cannot be.
My Lord.
Thank you.
Yes. Let my learned colleague to stick on our opening speech, not to make reflection of what he is in mind, criticize the prosecution. This is not the time for him. Thank you.
It's okay, sit down. Please.
Your Lordship.
Doctor, try to summarize, because we have written...
Mine is only 5 papers, and we have done 2, remains 3.
Try to stick to their...
Your Lordship, it cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a court credible evil, relevant, related, connected, and linked with the facts. One of the ingredients of the elements of the crime, which all of us, we know in this room, actus rea, mens rea, and causatio. We need our colleagues there to stick to these three elements, ingredients of the crime: mens rea, actus rea, mens rea, and causatio, which means physical act, criminal guilt, and connection between the act and the deed and the result. Your Lord, lawyer has a duty to see that all available legal proof of the fact is presented. It should be done firmly and pressed to its legitimate strength, but it must all be done fair. The role of the prosecution excludes any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an increasing sense of the dignity, the seriousness, and justice of judicial proceeding. Your Lordship, furthermore, Lord Macmillan, a Lord Advocate General in the Scotland, and a member of the Judicial Committee of the House of Lords of England.
Please, Giri, why don't you just give us the paper and then we gain the time instead of...
I'm doing. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, to ourselves, to respect this Honorable Noble God, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amount to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008, Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt. And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Gary, please,
Let me conclude. Moreover,
you just try to conclude.
It is just only 3 lines. Moreover, the defense records
Excuse me, Dr. Giri. You must know that Section 224 doesn't give you the right to respond. And we allow you to do that simply so that you enrich the procedures. Please try to summarize. Otherwise.
Thank you. I want to remind this Honorable Court that South Sudan belongs to common law and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, et limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud, Mohamed Taha, and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. Justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor, Albert Van Dyce, has come with his book about that.
I give you 2 minutes to finish your speech.
Thank you. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile State. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here, and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir. We don't have the road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lordship, the accused person have been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19, Clause 4 of our beautiful Constitution of the Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution, read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19(1) of the Transitional Constitution 2011 as amended, right together with the provision of Section 6P of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution operating in speech is filed with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, because to conclude I must, we will respectfully invite your Honorable Special Court to render the 8 accused person not guilty of any crime. Thank you.
Okay. It's good to. When written is written.
لا لا موجود موجود
Where is
موجود.
it? أشكر تفضل.
لقد تقدم الأستاذ مولانا دين تشيل ممثل الاتهام بتأجيل جلسة يوم غد الثلاثاء. إننا في الدفاع نعترض على الطلب الذي تقدم به ممثل الاتهام للآتي من أسباب: واحد، لقد ظل سيف الاتهام سلط على رقاب المتهمين منذ نهاية مارس 2025 إلى يومنا هذا، ولقد أخذ الاتهام في إجراء التحقيق والقبض والحجز لأكثر من 6 أشهر. إننا وفي اعتقادنا المتواضع لا نرى مبررا يستدعي تأجيل هذه الجلسة. علينا نلتزم المحكمة الموقرة رفض طلب الزميل والاستمرار وسماع المتحري.
Thank you, my lords. We all agree that this case has taken long, and in the interest of justice, it should move very fast. However, there are procedural requirements that we cannot jump, and that is providing this court our evidence. So we're requesting this adjournment, not because we don't want to proceed. We want to proceed, but the requirement is that we must submit this evidence to court, so that it will be in the custody of court as we proceed with the court proceeding. It is our right as well to request for the same. So we insist on our prayer for adjournment so that we proceed tomorrow in the morning after submitted and verifying with the court police all the evidence that should be submitted to the court. It is not our own making, but it's because of the speciality of this court, the nature of this court, the uniqueness of this court. If this court was existing on its own before, we would have done this long before today. Thank you.
You see, it is for these reasons we allow even the defense to respond, while we are aware that Section 124 doesn't give the defense the right to respond. This is number one. Number two, we agree with the request because each and every party is supposed to give evidence in a thorough manner. Therefore, the session is going to be adjourned up to Wednesday after tomorrow. Thank you.
My lord.
Go!
9 صباحا، لكنه يكون في الاستئناف بتاع يوم الليلة. المحكمة الخاص صباح اليوم جلسة المحكمة النائب الأول الرئيس الموقوف عن العمل الدكتور رياك مشار المتهمين معه بعد تأجيل إعدام 5 أيام. I'm joined here by the Super Memo, so you can just give us a quick one when it comes to what have been happening, Gibel.
Well, quite a lot happened during the fourth proceedings of the trial of suspended first Vice President Dr. Riek Machar and his co-accused. And the judge started the session today by responding to the objection to the special court by the defense team of Dr. Machar. And he gave arguments before actually making a ruling. And what happened, he basically objected or rejected the claims made by the defense team on the jurisdiction of the special court. And later on, we heard from the prosecution team leader, Joe Ohisa, who made a speech in which he actually read out the charges that have been leveled against the 8 accused, with Port Kang being the first accused and Dr. Riek Machar as the 5th accused. He explained based on how they have actually on the nature of the case, the crimes, alleged crimes that were committed in Nasir County of Upper Nile State sometime this year. And there was also a response from the defense team with regards to the statements. And so there are kind of comments or reservations he made about the remarks or the speech by the prosecution defense team. So in conclusion, the presiding judge of the special court, James Alala, adjourned the session to Wednesday, when now the official trial of the accused will begin. So I want to get into those facts, not to be misquoted or to avoid misrepresenting those facts. And we will look ahead to look into this in the next broadcast to state clearly what the facts are from what the presiding judge said, the arguments he put before rejecting the claims that were made by the defense team. And also we will get in those stories or broadcast some of the arguments that were presented and the other decisions, including the throwing out of 2 defense lawyers from the court. Yes. And one thing before I forget is that the presiding judge asked for witnesses, if they were there at all, to leave the courtroom, and he warned that if the court had actually discovered later on that some of the witnesses were in the court, they would not be allowed in the next proceedings to make statements. And so these have been some of the things that unfolded in the court. Yes. And just to mention, to be exact, the advocates who were actually thrown out of the court were Warnyang Kir Warnyang and Deng John. Yes. And there was objection to the statement or the claim by the defense team that some of the private lawyers in the prosecution team should not be part of that team, and this has also been rejected by the special court. So we will, for more details of this, those who follow iRadio on all the platforms, whether on our website, social media, and also the broadcast, will be able to get these details in the course of the day.
Okay. باختصار بسيط خالص إنه الليلة محكمة بيت الليلة يتأجل لحد يوم الأربعاء الساعة 9 صباحا، لكن في 5 بوينتس ممكن نتكلم عنه. الحصل شنو في يوم بيت الليلة اللي هو تعليق 2 من محامي الدفاع، وكمان قاطت المحكمة بين محامي ورنيان كير ورنيان والمحامي دين جون دين كلهم عضوان في الدكتور لا يمكن للفريق الدفاع عن المشار الاستمرار في تمثيل المتهم في مرحلة ده. وكمان تبين تراخيصهم كان مع النقابة المحامين في جنوب السودان كان كمان خلص، وأمرت المحكمة إنه تلتمس عقوبة من رئيس القضاء وتنظيم وضعهم قبل إعادة قبولهم شنو في المحكمة. في ثاني نقطة إزالة العقابات القانونية مع حل جميع الاعتراضات الأولية. وكمان أعلن المحكمة إن القضية بتنتقل حسي لمرحلة جلسة الاستماع الموضوعية مما بيسمح للمدعين العام بالبدء في تقديم الأدلة والشهود ضد المتهمين. في فقرة نمرة 3 إنه تم رفض حجة المحكمة المختلطة، لأنه كان إحنا كمان سمينا في أسبوع الفات ادعى الدفاع إنه المساءلة يجب أن ممكن تدرج تحت سلطة بتاع المحكمة المختلطة لجنوب السودان على نحو المتوخي في اتفاق السلام المجدد لعام 2018، لكن غير إن القضاء قرروا إن النظر فيه حسه المحكمة المختلطة لما ما بتشكل رسميا بعد، لكن ممكن الاحتجاج بها لإطاحة باختصاص المحكمة العليا. ونتيجة لكده أعلنت المحكمة في الاستمرار في الإطار القانوني والوطني الحالي. في رابع نقطة بيأكد حصانة تقصير على الرئاسة. حكمت المحكمة كمان بأن الحصانة الدستورية تنطبق بس على رئيس الجمهورية ولا تمتد إلى نائب الرئيس. وكمان في الأساس ده بيدعي الدفاع إنه الدكتور ما ممكن لم يكن من الممكن مقاضاة مشار أثناء فصله في منصبه. وآخر نقطة من محكمة بتاع الليلة إنه المحكمة العليا بتدعم الولاية القضائية، وبيأكد إن المحكمة العليا بتجلس في جوبا سلطاتها واختصاصها في رئاسة ومحاكم النائب الأول للرئيس الموقوف الدكتور رياك مشار ومتهمي المشارك فيهم بتعليق بحادث ناصر. وكمان بيأكد القاضي إنه الجلسة بيرأس إنه اختصاص المحكمة بيرتكز على الدستور الانتقالي لجمهورية جنوب السودان لعام 2011 بصيغة المعدل. بكذا نتقابل إن شاء الله يوم الأربعاء تماما الساعة 9، لكن at the course of the day أنا بقدر أوريكم أبديت البحث شنو في the updates اللي أقدر أعمله في court hearing الرابع في يوم بتاع الليلة. بكذا نمشي لفاصل بعدين أنا برجع لكم ببرنامج بتاع ساوند تراك شو. make sure إذا كان ما فولو لنا فوق فيسبوك تنا ولا في ويب سايت تنا you can always follow us on iRadio في فيسبوك في تيك توك في يوتيوب، كمان فوق ويب سايت تنا اللي هو www.iradio.org عشان كمان تقدر تعرف الكثير والقاعد يحصل نفسه في برامج المختلف، كان جا في كارن افيرز أو كمان في أخبار المختلف من جنوب السودان أو كمان برا. لكن حسي نمشي لفاصل ونرجع عليه. as on iRadio في فيسبوك في تيك توك في